Good morning, everyone. It's a real pleasure to be chairing the first panel. The organizers, I have to say, have picked a very interesting topic for the first panel, achieving international standards in the reform of financial crime. Of course, this topic presupposes a number of things, and that's probably why the topic is both interesting and probably problematic. Firstly, it presupposes that there can be international standards in this area. And of course, when one thinks about international standards in financial crime, I think immediately one thinks about the FATF, Financial Action Task Force, maybe also the UN Convention Against Corruption, where states are trying to come together to formulate some universal standards in this area. But of course, I would ask you to think, but how well are these standards actually implemented across nations? It may be easy to sign these agreements, but at the end of the day, to achieve international standards, it has to be implemented at the state level. The second thing that this topic presupposes, of course, is that international standards are actually desirable in this area. And I think many of you will appreciate that the problems of financial crime, although they are transnational, at the national level or the local level, they may be very unique depending on the jurisdiction that you're dealing with. And so, for example, I think about the fraud offense that we have in Hong Kong, and many years ago when our Law Reform Commission was looking at whether we should abolish conspiracy to defraud and have a new fraud offense, our Law Reform Commission said, following the UK, that we should keep conspiracy to defraud together with a new fraud offense, because the problems of fraud in this jurisdiction were such that prosecutors needed this tool of conspiracy to defraud. Another example, of course, is in the area of money laundering. Again, we have FATF setting some international standards, but then again, no two jurisdictions exactly have the same money laundering offense. And of course, in Hong Kong, as our speaker, one of our speakers will be telling us, has a very tough money laundering offense appropriate for the needs of Hong Kong. Another possible example is the area of prosecution of offenses and who should have the power to prosecute, a topic that our first speaker has been very outspoken on very, very recently. And again, is it necessarily an international standard that securities regulators should have a prosecution power? Is that the right position for Hong Kong, especially given our constitutional framework in Article 63 of our basic law, which provides for control of prosecutions to be with the Department of Justice? So these are some very, very interesting issues. And of course, if you have differences across jurisdictions, that then gives rise to the related issue of cooperation. When you do have transnational crime, cooperation across jurisdictions, because that needs to balance for the differences so that states with different jurisdictions can talk to each other when cooperating in this area. So these are just some of the possible topics that we can talk about this morning. And I know our speakers will have some very interesting things to say about these topics. And let me introduce our two eminent speakers in this area. Our first speaker really needs no introduction at all. Mr. Kevin Zervos, Senior Counsel, also our Director of Public Prosecutions. I think for those in the room who are from Hong Kong will know that this is an individual who's been very dynamic in his office, and he's been very innovative in trying to promote the prosecution service in Hong Kong. And he's also been extremely outspoken. And in fact, these last few days, as we know, as he winds down his position, I believe he's stepping out of office end of this week, as the papers say. And he's been very outspoken on various topics, and I'm sure he'll be sharing some of his thoughts today. I'm proud to claim him as my student. And you may be wondering, well, how could that be?
You screwed me up.
No. And it's possible because late in his career as a prosecutor in the Department of Justice, he made the decision to go back to school and to complete his master's in human rights. So particularly choosing our master's program in this area. And I think it goes to show his commitment and his passion for the promotion of human rights. I think we've been very fortunate to have a DPP of this caliber and with his interests in human rights, and it's reflected in the recent prosecution policy the prosecution report and the forthcoming code. This is, I think, a prelude of things to come this week. You'll see in this new policy document that the prosecution division will be publishing the respect for human rights that the prosecution service has adopted since 1997. And so let me invite Mr. Zervos at this point to share with us some of his thoughts in this area.
Right, thank you very much, Simon. And can I say it's a real pleasure for me to be here. I see some familiar faces, and I expect I'll get the typical questions that I always get from those familiar faces, but I'm looking forward to the dialogue that hopefully we'll engage in. I want to just say a few opening remarks generally about the topic, but I want to just say a few things about the way the prosecution service here in Hong Kong operates and why this particular topic is close to my heart. Because I realised very early that there was a strong need for me to reach out as a prosecution service throughout the region because of the importance of being able to work with your counterparts regionally and internationally. And in fact, we've implemented a number of programs to do that. We have a placement program where we're bringing prosecutors from other jurisdictions and work with us for a period of time, for a month or two. And we've had prosecutors from Singapore, Brunei, Kenya, and more recently from Mongolia. And it's all because I see it's important that we understand one another, we understand how each of our jurisdictions operates and functions, and it gives us an opportunity also to get to know one another so that we can deal with one another when we need to. I've found, as most of you would know, that my background is in white-collar crime. I've been a white-collar crime specialist for a little under 30 years and doing a whole host of cases in Australia and also here in Hong Kong. And to be quite frank with you, I don't think things have changed very much in that 30 years. And I remember the first paper that I gave back in the 80s in relation to responding to fraud and the initiatives and the issues that I stated then, and I will be repeating them to you now. Things haven't really developed, especially in relation to the international nature of crime. And that's what we're really focusing about. And I mean, we're in a whole new era where we now are part of a global community. That's why the emphasis is on relating to my counterparts regionally and internationally, because crime is occurring on a whole range of different, or traverses a whole range of different jurisdictions, and is in various forms now that we really need to be able to respond and respond effectively, which we're not doing. So, to some extent, you know, the approach that we've been taking here in Hong Kong has been to try and identify a case where we can deal with it within the jurisdiction. In other words, we've got the evidence domestically and that we don't necessarily have to rely on evidence from another jurisdiction. And we've got a number of horror stories that we've experienced in trying to secure evidence abroad and the difficulties and the frustrations that you go through. But let me make some fundamental points about our criminal justice system, and I think this is universal. We've got to make sure that we keep our laws simple, clear and concise. And I think what's happening now, we're over-regulating and we're introducing too many laws of a specific kind, when what we should be doing is keeping them simple and straightforward. And we all know when we're doing something wrong. And believe me, every member of the community, and especially in the area of white-collar crime, they know when they're doing something wrong. You know when you're acting honestly and when you're acting dishonestly. And so we should make sure that our laws reflect that fundamental understanding that we all have. And unfortunately, we're getting laws now that are becoming really very detailed. And when you see some of the legislation that we have here in Hong Kong, and I've seen it elsewhere as well, especially when they provide a whole series of defences that could be available, it becomes very convoluted and very, very difficult and confusing to be able to bring forward before the courts. And invariably these cases are lost on appeal if they're won at trial in the first instance. So that to me is very, very important. That we have our laws in a fairly straightforward, clear and simple and precise manner. I also strongly believe that there should be a separation of responsibility and powers between investigatory agencies and prosecutorial authorities. I know I've been a little outspoken about that in recent times, but I've always been fairly outspoken about it, but it's just now that I'm getting a bit of publicity on the issue. But I think that's important, especially when an investigatory agency has coercive powers. And a lot of these boutique law enforcement agencies do have coercive powers that are fairly draconian. And that's acknowledged. And so what needs to be done is to make sure that you have appropriate internal regulation as well as oversight in the use of those powers, because they are far-ranging and extensive. And that also that you have a separate prosecution authority that can check the law enforcement agency to make sure that things are being done properly. And at the end of the day, we are, or we tend to be, when we are a separate prosecution service, dispassionate and impartial in being able to make the assessment. We're not judge of our own cause. So there are many times, I can tell you, when I have dealt with agencies, law enforcement agencies, we have a fairly vigorous exchange of views. We've decided that they should be pursuing something or that they should be following up on something. They may refuse. They may give up, say that there's no need to look at it further. And we, on very many occasions, give them guidance and direction to pursue things. On converse, we sometimes advise them that there's insufficient evidence, that there's no basis to proceed to prosecution, and they may argue with us vigorously on that. But at the end of the day, it's our decision, and it should be. And as head of prosecutions, I'm accountable, and I've got to explain things. And that's the other thing that I think is very important for a modern prosecution service. The good old days when you can operate behind closed doors are finished, in my opinion. Community now is more knowledgeable and aware of its rights and freedoms and of the law, expects more from its public officials, especially me as a public prosecutor. And I'm there to be accountable to the public. And so we should be accountable to them, willingly. And I do engage openly the community and explain decisions. And recently we had a case that involved a public official of some standing, and there was a lot of public concern expressed about that particular matter, and I issued a statement, detailed statement, setting out the evidence and why we came to the decision not to prosecute. And then I subjected myself to a press interview where I fielded a number of questions in relation to that matter. So I think that's important, and I think as part of your development as a prosecution service, or ensuring that the interests of criminal justice are being pursued, that we've got to have some fundamental concepts and philosophies about how that should be done. And I think internationally that has reached a point now where it's fairly well established. We have a body like the International Association of Prosecutors. We have our own HOPAC, Heads of Prosecuting Agencies conference, which is Heads of Prosecution Services of Common Law jurisdictions, come together. And I can assure you that there are fundamental principles and concepts that are now universal. And of course, they're littered in all the international agreements and conventions And those principles and concepts are now fairly well established. So I do believe we can have an international order. We should have had one a long, long time ago. But at the moment we're still operating like we used to, as I said, 30 years ago. Now there are ways of being able to make sure that we are dealing more effectively with transnational crime. I mean, we have certain UN commitments and conventions in relation to this, as well as regional treaties as well. But it's not working. It's not working, and I think these are the problems. And I think it basically boils down to the fact that we're different jurisdictions. And we're different in a number of ways. We're different in our stage of development and maturity as a criminal justice system, and we're also different in terms of the different legal systems that may operate. You know, an inquisitorial system operating, or a civil system as we understand it, operating in one jurisdiction compared to a common law jurisdiction with another. And that creates problems and issues. Now I've had, and I have experienced problems where we have the issue of concurrent jurisdictions, then the respective jurisdictions trying to claim a stake in relation to the criminality involved. So there's competition, there's conflict, and these are legally real problems. And I'll give you some examples. We had a case, a major illegal gambling operation that was occurring in another jurisdiction outside, but it was all operating in relation to horse racing here in Hong Kong, and the proceeds of the illegal gambling operation all ended up in Hong Kong in bank accounts. Now, the operators got dealt with in the other jurisdiction for illegal gambling and for money laundering, and I suspect to some extent by arrangement, because they were appropriately acquitted. And so then we had a difficulty in relation to autrefois acquit, because once we had arrested and wanted to deal with them here in the jurisdiction. Anyway, eventually we were able to identify separate criminality in terms of money laundering and successfully prosecuted the individuals. But you can have issues and problems like that when you're not communicating with each other or properly coordinating your activities, and there tends to be a sort of a selfish desire to pursue your own matter and for your own interests. And I'll come up with the problem that we're experiencing with separate investigatory agencies, especially involved in policing securities that operate throughout the world. And but that was one example. Another example is where we're seeking evidence abroad, and we're involved in a major fraud prosecution here in Hong Kong. There's a tendency to fight the proceedings in the other jurisdiction, and that can take years. They'll start running arguments, they'll start making allegations, and that can take, as I say, a long period of time, to the point where by the time we get the evidence, the trial will be well and truly over. And so this is a tactic that I see is coming up more and more, is being employed. And we're up against people who are fairly wealthy and have the resources. In fact, the notion of the might of the state versus the individual is nonsense, in my opinion. It's the might of the individual versus the poor, undernourished state. And we have a whole array of lawyers, admittedly, in our prosecution service, but they've got about 10, 20 cases each of them is doing, where an individual will have a dedicated team of lawyers working against us, and they tend to be well-resourced and well-funded. And so, on that basis alone, we're at a disadvantage, and we see that with major fraud. So you have situations where they're frustrating the processes. So when you go overseas to try and secure the evidence, with their resources and ability, they're able to frustrate the processes and delay things inordinately. The other thing that happens as well is that when you are dealing with concurrent jurisdictions or other jurisdictions in the criminality of a matter, there's a competition sometimes, and that what they do could jeopardise what you're proposing to do in the jurisdiction that you're in. So there really needs to be greater coordination and also some serious thought about the best way to deal with a particular case. The other issues that do come up is also problems within our own jurisdiction. You know, when we are pursuing matters on behalf of another jurisdiction, you know, we too also get subject to prolonged litigation. We also have the issue of, you know, making sure that this is reliable, credible information. You know, whilst we feel confident what we're giving out to another jurisdiction, sometimes we don't feel so confident about what we're receiving. And we have to make sure that it's right and proper. I mean, we've got our reputations to maintain, and we've got our standards to keep as well in this jurisdiction. So that is also a problem and an issue. And, you know, it goes back to the notion, the underlying problem that I think that we have, is that different jurisdictions at different stages of development, different ideas of how to do things, different legal systems. So that, to me, is the core problem. Some of the ways that we've got around it, and, you know, believe it or not, we've enacted legislation to take video link evidence, but we haven't promulgated the rules in relation to them. It's still sitting there on the table. Yes. And, you know, it's just ridiculous, to be quite honest with you. And so I've been making a lot of noise about trying to push that through, because that to me is one way of being able to maybe deal with the problem that I've identified through video link evidence. Although that requires a degree, again, of cooperation and a degree of enforcement of the jurisdiction where you're seeking to take the evidence, because you'll have to have some form of power to bring the individual, subpoena, to bring the person to the court or to the place where the evidence is to be taken, and make sure that there's compulsory attendance. But that requires exercising power in that jurisdiction. So it's not all easy sailing in that regard. The other that we've done recently with the mainland is that we've reconstituted the court. We've taken the whole court to the mainland, set it up there and taken the evidence. And we've done that with the cooperation of particular provinces, but again, that depends on where we're seeking to do that in relation to the mainland. And it may be a way of dealing with it with other jurisdictions. The issue really, I think, boils down to this in terms of a solution. And I've been saying this for a long time. I really think we need basically an international law enforcement body. I mean, this is the ideal. Whether we achieve it in my lifetime, you know, I have some doubt. But this is the way it should be, and I believe it's heading this way. But we have an international law enforcement agency that can just traverse jurisdictional boundaries and requirements, and operates according to a set of rules and criteria that are universally accepted by everybody. And they can go into a jurisdiction and take action according to those rules and criteria that have been accepted and secure the evidence. So we really need an international police force with the appropriate powers and the ability to be able to exercise those powers in all jurisdictions. Then we need to have, obviously, a court that's going to be able to deal with that. And I've always hoped, and I was, you know, at the time when there was the talk of the International Criminal Court, that at last, you know, we've got a solution. Unfortunately, it's very, very limited. Unfortunately, a lot of major players didn't sign up to the Rome Statute either. So that was a disappointment. But we need an international criminal court, a truly international criminal court, that is able to deal with international crime. And so that if you have an international law enforcement, then you have an international criminal court that then will deal with it. And again, according to a set of law and criteria that is universally accepted, and that should work and operate. So it does require a layer, an international layer, global layer of law enforcement and prosecution. And that, to me, is the only way we're going to be able to get around it. I can assure you that in terms of the experiences that I've had as a prosecutor in white-collar crime, the criminal activity is becoming more and more transnational. And it's not only in white-collar crime, it's in a whole variety of areas. Now, to some extent, and I won't steal the thunder from Rowan, because he'll talk a little bit more about money laundering, but the FATF model is not a bad model. And the FATF model is one that could be used in other areas of criminality, such as corruption, such as human trafficking, and so on. And it has been effective. The only criticism I have about the FATF model is this, that it has a set of standards and requirements in terms of what's required by a particular state or country. Trouble is, certain states and countries, they're not at a level of maturity in terms of their legal system or criminal justice system for such an institution that is being proposed, or such a body of laws. And it should be done gradually in that situation. You know, there are some states that I've been involved in helping with their money laundering regime, and you can see that it was ridiculous to impose upon them the full scale of measures and requirements that you would expect of a truly developed state or country to have, when it's not going to work and it's not suitable at their stage of development. So I'm more of an advocate for block building, ultimately reaching that particular level, but for block building and helping a state or country along progressively and gradually, and making sure that they're able to have means that they can actually use and will use, as opposed to something that is, it's like buying a Rolls Royce to just go down the street every day of the week when you can do it with a bicycle. So this is an issue. But having said that, FATF has achieved a lot of success in being able to bring the community of nations together, start working together, start having a universal plan of action, and also the system of assessments of each other. Name and shame is also important to make sure that states and countries are doing something about money laundering, and it has been working. And I think we have been successfully tackling money laundering internationally through the efforts of FATF and other regional bodies as well. So on the final point that I want to make, because I'd rather have a dialogue, it's the importance of the notion of the rule of law. Andrew picked up on this in his keynote address, and I think it is very important that we not only look at the rule of law in terms of its aspirational objectives, but we also must realise that the rule of law requires a range of institutions to underpin it. And you need to bear this in mind, that in looking at the rule of law, you're not only looking at what your objectives, equality before the law, fair trial, due process, etc. But you're also got to make sure that you have an independent judiciary, well-trained, well-staffed law enforcement agencies, independent prosecution service, a free, responsible press. I say responsible press as well as being free. And a form of corporate governance that is representative of the will of the people, etc. So these are all important notions that one has to look at when we look at the rule of law, and understand its application universally, because we should also be ensuring, and I prefer to refer to the just rule of law. And what I mean by the just rule of law is the just application of just laws. And that's what we should be seeking to do in all our jurisdictions, wherever we come from, is to make sure that we're upholding the just rule of law. Thank you.
We're going to have time to have a more general discussion, but while I'm thinking about it, Kevin, maybe I could just ask you a question. I think you've talked about a lot of sovereignty barriers in this area, and of course in Hong Kong it's not just sovereignty, it's also regional between one part of China and another part. And I think it's quite admirable what you're trying to do in bringing foreign prosecutors into Hong Kong, so that you can sort of learn more about the different systems to try to hopefully, I guess, overcome sovereignty barriers, and maybe someday if you do have a case, for example, with Malaysia, or with another jurisdiction, that things could be more cooperative and more collaborative. So I just wonder if you could say a little bit more about whether that's the proper approach to take, and whether that could be developed further. Does that help to overcome some of those barriers?
Well, look, there's two ways that you cooperate with each other, formally and informally. And the informal cooperation is the most effective. The formal cooperation, I mean, most developed legal systems will have mutual legal assistance and appropriate treaties of cooperation and relevant laws for extradition, exchange of evidence, so on. But as I've explained, they can be time-consuming and cumbersome. And there are serious legal issues that always seem to come up time and again. It doesn't stop. When you are seeking to secure information or evidence in one jurisdiction, or you're seeking to provide it. You know, we ourselves have had situations within this jurisdiction where proceedings are taken out to frustrate and delay the obtaining of information and evidence for another jurisdiction. But the informal cooperation, and that's why I'm a great believer. I've been trying to advocate this for the time that I've been DPP, is to have a similar system that they have in Europe, like Eurojust. And we've discussed amongst ourselves at my particular level with my counterparts having an AsiaJust. I've tried to push it at the various conferences and groups and get-togethers that I've had, and we seem to be in agreement, but we really haven't taken it that one step further as actually implementing it. So I have, in my own way, tried to do my own AsiaJust from Hong Kong. And that's why I've had this exchange program. That's why we actually had, I don't know whether you know about this, but Simon does our training program for us. And we have monthly lectures from Simon as part of the importance of training prosecutors on current issues. And we had it done video link with our Singaporean counterparts. So whenever there was a topic that was discussed during the year that may interest our counterparts in Singapore, we organised a video link so they could participate. And now recently at the HOPAC conference that was here in Hong Kong in May, we've decided that we're now going to start looking, this is heads of prosecuting agencies of common law jurisdictions, to see what training modules we could use and appropriately film, make sure that you could download on your phone and watch it as you're going to work. Training modules that are universal, that we can exchange with each other. You know, for instance, in issues of advocacy, especially with common law jurisdictions. There's no need for us to be redoing it or doing it ourselves. We should be borrowing from one another and try to make things more efficient and cooperate. But the informal, in terms of actual practicalities, in terms of dealing with cases, that's why it's important that you do have a liaison and a communication with your counterparts, because you can ring them up, because you can give them a call and find out, well, what are your procedures? What do we need to do to make sure that we get this through quickly and promptly? And could you look out for this for us? I mean, this is what's happening now. And to me, the informal cooperation is the most effective tool at this stage. And the other thing that we've been doing as well is we're bringing in prosecutors from other jurisdictions to actually see how we operate. And I've had exchange programs with my mainland counterparts for years, and I go over there on duty visits constantly. And and I've noticed there's been a gradual improvement in the criminal justice system in the mainland. I'm impressed every time I go. And I can see also we're having an influence on them in terms of the way we're doing things. And they're always inquiring as to how we operate, and they're interested in the notion of a trial before a jury, the examination of witnesses, etc. Now, so we can influence and interact with each other, and hopefully we can improve the level of criminal justice not only in our own jurisdiction by being more effective, but also in other jurisdictions. I see as DPP of Hong Kong, because I see that I'm basically in a legal oasis in a sea of lawlessness. And I have an obligation to make sure that I develop the criminal justice systems of my neighbours so that standards will improve and that we'll be working at the same level. So that's also a very, very important issue and another part of the informal cooperation. But I can say that informally we do deal with one another and we're able to be quite effective in that regard.
Kevin Zervos has put forward a couple of provocative solutions to the problem. He's talked about having an international police force and also an international criminal court, in addition to the one that's currently in The Hague. And we're extremely fortunate today that on our panel we have an international judge who may hopefully be able to comment on these proposals. Judge Rowan Downing is, of course, a war crimes judge in Cambodia. And, of course, I could detail his over 20 years of international experience in legal developments around the world. What I want to just highlight in this introduction, of course, is a very interesting Hong Kong connection that he has, which I learned about last night. People in this room will, of course, know the name Warwick Reed, the very infamous prosecutor, very senior prosecutor, who in the 1980s and I think early 1990s was extremely corrupt. And he channeled most of his corrupt bribe money into New Zealand. I think most people know this. Of course, it gave rise to a very famous Privy Council case, Attorney General of Hong Kong versus Reed, which I know all students of trust law has to read because it's an important authority on constructive trust. It's come under severe attack recently by English courts, but it still, as I understand it, represents the law in Hong Kong. But many people probably did not know, and I didn't know this until last night, is that Mr. Reed also funneled some of his bribe money to the small island state of Vanuatu, where Judge Downing has been a judge for a very long time. And in the early 1990s, he happened to be a judge in a case where the Attorney General of Hong Kong had, I think this was after Mr. Reed had been convicted in Hong Kong and a restitution order had been obtained in the Hong Kong courts, but it was being enforced around the world. Right? And it was an example of the Hong Kong government being a party and going directly into the different jurisdictions to enforce that restitution order and to try to register it against funds that were in that jurisdiction. And Judge Downing happened to be the judge hearing the case. And of course, just to make a long story short, we're, I guess, thankful that Judge Downing did register the order, and the Hong Kong government was very happy to have I think it was $2 million returned back to Hong Kong in that case. So with that introduction, may I invite Judge Downing to share his thoughts on this topic.
Right. I've been working in relation to transnational crime and anti-money laundering for approximately 20 years, such that my children, when asked what I did at school, they would say, "Oh, Dad's involved in money laundering," which caused me a great deal of trouble. But I'll share some of my experiences with you, and looking at the particular topic. International standards. What do we mean by international standards in financial crime? Do we draw these standards from the common law? Do we draw them from civil law? Do we draw them from Islamic law? Or do we draw them from a mix of these three systems? Islamic law is a bit more difficult to include, but certainly there's very little difference between civil law and common law in relation to standards, or the laws at least. Reform, well, that's another issue which I'll come to. Why do we need it? Why should we be looking at this? And it's because we live in a global village. Money moves very quickly, almost instantaneously, from banks and financial institutions in one country to another. It's necessary to track it. It's necessary to try and work out where it's come from. Has it come from illicit dealings in some way or another? Where is it going to, and for what purpose? To what extent should the state be interested in this? Are banks and financial institutions, however defined, entirely overburdened by this? And are we looking at issues from an historic point of view, or are we looking at them in real time, if that's possible? Do we have issues with regulations of banks and financial institutions? Are they now motivated in a manner which they have not been motivated in the past, and I'm talking about 20 or 30 years ago, by greed? We have people who work within banks who their primary motivation is to get the bonus. How do you get the bonus? You get the bonus by being the top performer. How do you become the top performer? Well, by outdoing everybody else. Now, this may be a question of banking ethics, banking regulation and control. We have in the world at the moment a great number of economic regulators. And you still have trams here. I personally regard economic regulators about as strong as someone, or their effect is about as strong as someone getting a tram ticket and wetting it and wiping it across someone's face and saying, don't do it again. There has to be some form of regulation in order to prevent the financial crimes. If we look at what's occurred in the last 15 to 20 years, we have the United Nations Office of Drug and Crime. They base their mandate on illicit drugs and money laundering. And they're very good, and I don't want to be quoted on this, but they're very good at putting out reports. They're very good at having think tanks and having meetings, but the implementation, the identification of laws which can actually move forward to represent international standards is very difficult. It's very difficult because countries don't like to give up their sovereignty. They do not want to share sovereignty in criminal law. They see this as a diminution, and it doesn't work. Now, generally speaking. But in some areas where there are special connections, such as the European Union, you do in fact see a merger of systems, the production of standards, and an enforcement through reform that works. Will that be the case for ASEAN in a few years? Is this an opportunity for ASEAN to actually grasp the nettle and say, yes, whilst we have common law jurisdictions and we have civil law jurisdictions, as in Europe, we can bring reform together in relation to financial crimes, and we can be effective in relation to it. I then look at the OECD and the FATF, which is part of the OECD. I personally don't see, notwithstanding what's been said by the DPP, I don't see the OECD as having a role in relation to the reform of criminal laws. It's acting entirely from a self-interested point of view. It wants to prevent tax avoidance and some money laundering as a consequence of crime, but it's largely based on tax avoidance. It's something which is not done by way of agreement. It's done by way of the imposition of a process. You have the 40 recommendations plus 9, which are imposed upon countries. And so, as the DPP referred, you have countries which are not ready. And all of a sudden they find themselves having to have the predicate crimes. They have to have institutions which are not actually functional. They are expected to be functional. You have organisations such as the World Bank and the Asian Development Bank giving loans and grants where there is a matrix of conditionality which must be complied with, which will include the introduction of financial intelligence units and the predicate crimes. The judges are not ready. The courts as a whole are not ready. The prosecutors are not ready. The financial intelligence units which are established are not ready. And it's from jurisdictions such as Hong Kong that there is leadership in relation to the training. And this is an exceedingly important role to help regionally develop the strength. But it's not something which is coming from the bottom up, it's something being imposed down on countries. And I don't think that it doesn't help with ownership by the countries. I look at the Cook Islands, almost economically destroyed because of sanctions. They didn't meet the requirements, so they were denied the right to trade in the US dollar. Letters of credit are written in US dollar, so you can't trade. So that was a major problem. When I was in Vanuatu as the Solicitor General and Acting Attorney General, I was given a tip-off by someone from FATF meeting in Paris that Vanuatu was about to be put on the non-conforming list. So what happened was that I immediately, and that was on a Friday, Saturday morning, I went and saw the Prime Minister and I said, you've got to sign this letter. In this letter, you have to guarantee that you will draw laws, you will recall Parliament, you will pass the laws, and you will have an operational financial intelligence unit within 8 weeks from today. We did it. But it was something which was not particularly owned by the country. I might add, and I'll give you an example shortly, that Prime Minister was the first Prime Minister who went to jail for money laundering. And he didn't realise the import of what he was actually signing. But it really is very difficult to bring nations together. Even in my own country, Australia, upon federation, each of our states had different laws. And the federal government brought together the laws and there was reform of financial crimes. It's still not, in fact, complete after more than 100 years. And we have a federation, very close federation. So it's something which is very, very difficult to achieve nationally and internationally. Now, if I can give you some examples of what's occurred, or things that I've been involved in, and just to give you an idea of the need for cooperation, the need for countries, when they're asked for assistance, to take the view that your financial problem is my financial problem. So I will immediately respond. I won't wait for 6 weeks to look at the file. I won't wait for 8 weeks to look at the file. I'll deal with it immediately. And I'll give you an example. When I was in Vanuatu, I was sitting in chambers and all of a sudden an account arrived from a solicitor. It was $15,000. It was for legal services which I had not authorised. The account was sent to me by the Secretary of the Prime Minister. She knew that all legal bills had to come up to the State Law Office, so she just sent it up to me. I then phoned the legal firm, which was an Australian legal firm, and I spoke to the partner involved and I said, "What the hell is this about?" And he said, "Oh, this was work for the Prime Minister. There were some bonds that were issued. Don't you know about the bonds? And there were some derivatives which were drawn from the bonds." And I said, "No, nothing about them." He said, "Well, you pay the $15,000 and I'll tell you." And I said, "Well, I'm sorry, I'm not going to pay the $15,000, but you will tell me." And he said, "No, not going to do it." So we then put through a formal request for mutual assistance to the Australian government. 6 weeks later, we had had no response. Meanwhile, these derivatives were floating around the world, sufficient to destroy the economy of the country. The amount of money involved was absolutely mind-boggling. We ended up by going across to see the Attorney General of Australia and said, "Look, we're getting no response from you, we're getting no response from the Australian government. If something isn't done, a country that you support is going to die. It will be destroyed financially." That then motivated a raid upon a firm of lawyers. Documents were obtained. It was then discovered that, in fact, they had not complied with the Australian law. They had not registered with AUSTRAC, which is the Australian Financial Intelligence Organisation. They hadn't registered the transactions. They had put documents into a bank. The bank knew that they were holding original government bonds, purportedly original government bonds, but they too didn't comply with the regulations and notify AUSTRAC. At that point, we started to look for where these bonds had gone, and the derivatives, at least, from them had gone. So we went from Australia to Mauritius, to Kenya, to the United Kingdom, to France, Switzerland, Thailand, Indonesia, Malaysia, and we had assistance from the United States of America. And within 10 days, using the informal system followed up by formal requests, we were able to trace those funds. And there were people prosecuted in Germany because they'd bought the bonds. They had bought the bonds in Mauritius, and they had done that as part of transfer pricing and tax avoidance in Germany. There was a general in Thailand who was prosecuted because he'd sold $2 million worth of arms, which ended up in West Papua with the West Papua Freedom Movement, so that was terrorist financing. Then there was a container load of arms that arrived somewhere else in the Pacific. And the Prime Minister, who was ultimately responsible for issuing these bonds illegally, ended up in jail for 3.5 years. Now, we were able to be effective because of cooperation, and that was exceedingly important. But there are other instances where large countries, the big boys, and we're talking about 5 or 6 countries are driving this internationally. And I would sit in my office and I would receive requests from the United States of America. And they would come in by fax, and we had designed our law so that we had call, and we had judges on 24-hour duty, and we could walk into a court. I could say, "I'm exercising my right of call. I would like the court now to go into in-camera session," and I would get freezing orders from the court. I would always explain to the Americans, "I can get the freezing order, but you need to provide me with the hard evidence in 7 days, because I will only have an interim order from the court. And as a consequence, you need to get this material to me. I did this on 4 occasions. Not once did the Americans come forward, the American State Department, come forward with the supporting evidence. And I got to a point where I had to say, sorry, you give me the evidence, then I'll make the application. I am not prepared to be embarrassed before the court any further, and I'm not prepared to embarrass this country any further in relation to its compliance with international standards. You need to do it as well. And by the way, what about Delaware, what about Montana, and what about Utah? Because the Americans, unfortunately, whilst they would like to think that they comply with the international standards of the FATF, they don't. They have 3 states which are rogue states, and they will not bring them into compliance. It's very, very difficult. At the moment, we have, as a live issue, the LIBOR fraud in the UK. And you probably are all aware of the LIBOR fraud in the UK, where there was the manipulation of the LIBOR. A number of banks have been dealt with in America for LIBOR fraud. They have paid huge fines. Cases based on the same original activity are about to commence in the United Kingdom. And it raises very interesting issues as to in how many jurisdictions can you be dealt with for the same offence or a slightly different offence. It's an issue of should you in fact be dealt with in every jurisdiction where someone has been affected? The answer is probably yes, because it's a global offence and countries wish to express their sovereignty. And I know in the LIBOR case that the American government have been desperately trying to get the British DPP to withdraw the case because it's already been dealt with. But it's very, very difficult from a jurisdictional point of view, from a sovereignty point of view. How do we draw some sort of sensible approach to international financial crimes? And I'm not sure, other than an international police force and to extend the jurisdiction of the ICC beyond the war crimes jurisdiction and crimes against humanity. I'm not sure that will occur. I can give you just one final example, and that involved Hong Kong, as well as Australia and Singapore, and it was a pump and dump. And I'm not sure how many of you know about what a pump and dump is. But a pump and dump is where you buy shares in one country, let's say 10 cents. And then someone on another exchange, a particular example was Melbourne, shares were bought at 10 cents. Hong Kong, shares in the same company were bought at 20 cents. Back to Australia, another 10 cents added. Singapore, another 10 cents added. Hong Kong, another 10 cents, until the share value was pumped up to $1.10. And whilst the shares were going up, there were people who were jumping on board. Now, there's something going on with this company. The shares are rocketing up, and it's not just in our jurisdiction. It's a number of jurisdictions. They got up to $1.10, and they dumped. The fraudsters dumped the shares onto the market, and they did very nicely, because when they averaged the value of their share purchasing, they bought a lot at 5 cents or 10 cents, and very few as they went further up. But they were able to pump the price up and then dump. And I prosecuted in this case, and it was the first one of its kind in Australia, where we were able to demonstrate by electronic means, second by second, the movement of these shares because there was cooperation between the exchanges in relation to this commercial fraud. And Hong Kong gave its tapes, Singapore gave its tapes to Australia, and so on. And it was something which led to cooperation because the corporation was registered in Australia, primarily. That's where it had its primary activity. There was no attempt to prosecute anywhere else in the world. So it was an example of cooperation. And it was informal cooperation initially, which was formalised. And that's the real thing with international crime. The reform really needs to be in relation to cooperation, the identification of primary jurisdictions for the purposes of prosecution. Thank you.
Thank you, Judge Downing. Your story of the U.S. request, I'm sure, made people here think about a recent U.S. request for extradition. Now, back to this idea of an international police force or international court. And of course, we do have Interpol, and why isn't Interpol such an organization? And of course, even if you do have an international court, I mean, international courts rely on cooperation. Cooperation with the states that have the evidence and the witnesses. And so you're back to that same problem again. Wouldn't you agree?
I entirely agree, and I can actually give you a lovely example of Interpol and its functioning in Australia. I was on an aeroplane flying into Australia. There was, to my knowledge, on the aeroplane, a man who was, his name was Anandranath Ghosh. And Anandranath Ghosh was actually involved, I think he took $15 million from BNP here. And I knew, because I had in my office back in Vanuatu copies of the warrants for his arrest, the international warrants for his arrest. I sent a note to the captain of the aeroplane asking him if he would notify the Australian Federal Police before we arrived in Sydney that Anandranath Ghosh was on the aeroplane and that there were at least 7 Interpol warrants out for his arrest. It was a Saturday. When we arrived, indeed, there was a federal police officer who met me, and I informed him of the warrants, and he said, "Do you have copies?" And I said, "No." Well, the Interpol office was closed. It was Saturday. And Mr. Ghosh moved on to another country. So there are limits, unfortunately. And yes, Interpol is a very good organisation, but again, you need to have cooperation, you need to have knowledge, you need to have people who are prepared to act. And it is actually very personality driven. And I've had dealings with Hong Kong. Hong Kong's response has always been excellent. It's your problem is our problem. New Zealand, ask New Zealand for assistance at 9 o'clock in the morning. They will give you a response by 3 o'clock and an apology for the delay. Thailand, absolutely dynamite. They are vicious. Malaysia, even more vicious. Australia, well, they're probably having a barbecue and it's well, it'll take a while and it might be a bit much of a problem. And so that's the way it works. And if you don't actually know someone, if you don't have personal contact, it's very difficult to go through official channels in this area, unfortunately. But it shouldn't be. It's the personal contacts, and we're at the moment that I think drive, but it shouldn't be at all the way in which it works. And I don't know if the Honourable DPP has something to say about that, but until we have systems in place which actually work on an international basis, then we have a real problem and an ineffective system.
Well, yeah. My experience is similar. Interpol does good work as far as it goes, but it's basically a mailbox, and effective in relation to red notices, but it's not the notion that I'm coming up with in terms of an international police force. It makes contacts and brings about contact from one state's jurisdiction with another, but it's extremely limited.
All right. I think at this time, I'd like to open it up to the audience. If anyone has any questions or comments about anything that we've discussed, you're most welcome to raise your hand. Who wants to begin? Oh, Lester.
Hi. Kevin, just very interested in this concept of regional or even international police. Who's going to finance this? Who's going to initiate it? Who's going to actually be the watchdog of this arrangement?
I thought we'd probably increase some solicitors' fees for licensing. Don't forget, just like any criminal justice system, the system itself is a checks. The courts will check the conduct of the law enforcement officers and of prosecutors as well. Although I would imagine that in such a structure you would have the internal regulation and checks and balances that you would in a normal body that you would have operating domestically. As to its financing, I think it'll pay its way very, very quickly. I think it's going to just imagine the amount of money that is being circulated throughout the world in terms of money laundering and fraud and all host of other crimes, organised crime, human trafficking, etc. And the effectiveness too in terms of being able to restrain and confiscate. It should have those powers as it would domestically. So it would be paying its way in the first week of operation.
Just to add to that, my experience in Vanuatu was that in 2001, we had running through the country for fraudulent or money laundering purposes something in the order of $104 billion that we were looking at. We couldn't catch it all, we couldn't catch most of it, but we were able to alert others as to what was going on. And we even had money which came from a certain Middle East security organisation. Now, we did catch that and we did confiscate it. And at one point, the Financial Intelligence Unit in Vanuatu was contributing 12% to the total budget of the country in confiscated funds.
Can I just follow up on that in terms of money laundering? You probably recall not long ago I was the subject of considerable jousting with the South China Morning Post, who were critical about our anti-money laundering laws and that we were pursuing people that were the small potatoes, etc. You know, the amount of money that we identified just here in Hong Kong that we restrain and we confiscated is astronomical. And in fact, I'm noticing now there's still a lot of money coming through Hong Kong in relation to drug trafficking. That was always our problem initially. And when you look at the development of our anti-money laundering measures, first focused on drug trafficking, and then under the Organised and Serious Crime Ordinance, focused on serious crime. Now, more recently, we've noticed that there's a huge amount of money being laundered through illegal gambling. And we had one case where it involved an operation in another state, but the money and it related to Hong Kong because they were betting on the Hong Kong Mark 6, believe it or not. And the monies were being deposited in Hong Kong. And we restrained the monies and confiscated through the abscondee proceedings because the wife came over to try and retrieve the money. And we confiscated $1.5 billion. And that was just a small little operation of illegal gambling that emanated in another jurisdiction. And we're finding that in illegal gambling there's a lot of money that is... and also the other thing is that the crooks want security. They're not going to deposit their money in some backward state where they're likely to lose it overnight. They're going to put it in a country or state that has an established financial system. And that's why you see a lot of money laundering going on in London, New York, Hong Kong, Sydney, where there's established financial institutions and a system where the crooks can get certainty and stability and access to their funds.
More questions? Yes, there's a woman here.
My question is addressed to Mr. Zervos in relation to the very interesting topic you raised about the security regulators' power to prosecute. You mentioned two scenarios, the first being where the DOJ takes the view the case should be prosecuted and the securities regulators think that there's insufficient evidence. But what about the fact that there's a provision under the SFO which says the Commission's prosecution power does not derogate from the DOJ's power to prosecute? Just wonder what's your thoughts on that. And when you mentioned when things happen the other way around, which is where the securities regulators decide there's sufficient evidence, but the DOJ thinks there's not sufficient evidence. What about the Commission's recent response to that, which says that in the past its success rate in the prosecution is above 90%? Just grateful for your feedbacks and thoughts on that. Thank you very much.
Well, that's always a worry when somebody's bragging they've got a 90% success rate. Either that means that they're only prosecuting the certain cases, or that the figures are not accurate. But I don't think that that's something that one would beat their chest about. I remember not long ago when we had a similar claim in relation to our prosecution figures, and the profession actually came out quite critical, saying, well, these figures are too high. And you'll find that, in fact, we were then equated with North Korea because they've probably got a 90% success rate. But you find that in terms of cases, contested cases, you'd have a fairly healthy proportion of 60 to 70% success rate, because you're not prosecuting the certain cases. You're prosecuting cases on the basis that there's a reasonable prospect of success. So you shouldn't be just prosecuting the certain cases. It's either that or you're prosecuting to a point where you're really securing a conviction at all costs. So it's not something to brag about. Because at the end of the day, when a case does succeed, it's done on a beyond reasonable doubt. So there's going to be a difference in terms of you bringing a case before the courts. You bring it before the courts on the test of a reasonable prospect of success. But the court will ultimately decide it on beyond reasonable doubt. So there's going to be cases that you lose. And that's why you have a 60 to 70% success rate and other issues that may arise. In relation to the comments that have been made recently with myself and the SFC, I firmly believe that you should have a separation of responsibility between a regulatory and an investigatory agency and a prosecution service. And it's simply because, and it's just my experience over the years as a prosecutor, I'm a dedicated prosecutor. I'm trained, and I think in terms of a code of maintaining a very, very high standard of fairness and justice. And I've got to make sure that cases are put before the courts fairly and properly, because once you start dropping your standards, and once you start trying to win at all costs, then your criminal justice system will just be destroyed overnight before your very eyes, and you'll lose credibility. And what we have here in Hong Kong is the rule of law. And what's an important component of that is a fair and just criminal justice system. So I raise that. I'm not saying that the SFC necessarily would be a reason for that, but it's just that there's a tendency with investigators to look at it as an investigator and they're pursuing a particular person or a matter, and they're keen to get a result, where a prosecutor is not. They're not trained that way. A prosecutor's got to assess the case, look at sufficiency of evidence, and make sure that the case is one that should go before the courts as well, on the basis of public interest. But it's an assessment of the evidence with the particular standards and requirements in mind. So I've had many meetings with investigators, to give you an example, and they've disagreed with my decision either not to prosecute. In many cases, we advise ICAC, the police, SFC, not to prosecute. And they will come back and they'll be thumping the table and they'll be saying, we want to prosecute. Now, I'm confident the decision that I've made not to prosecute is one that is right. And I have that responsibility. Now, if the investigator had their way, they would prosecute. And so you could get situations, and you do if you allowed the system to develop this way, where an investigator is prosecuting not according to the principles and standards of a prosecution, but according to their desire to get their target or to pursue their case. So that's the problem I have in terms of the division of responsibility and the issues. Now, I know the particular provision that you're referring to and the figures that were given by the SFC. To some extent, I think there's a play on facts and figures in relation to the comments they've made, but there are a lot of minor cases that deservedly went to the magistrates' court, and they have a regulatory function, so that they're going to be pursuing matters that where there's offences under the regulations, which aren't as serious as the sort of cases that I'm talking about, and the sorts of issues that I have with the SFC. But I'm not one that's going to advocate the abdication of the prosecutorial responsibility to an investigatory or regulatory body because of certain concerns that I would have. And whilst there is provision under the SFO, I think it's section 388, which talks in terms of the prosecution responsibility that's limited and given to the SFC. It's only in relation to magistrate court matters, and it's subject to the overriding responsibility of the Department of Justice under Article 63, or there's no direct reference, but obviously that's the indirect reference under Article 63 of the Basic Law. But still, that depends on the relationship and the way things are done between the investigatory body and the prosecution service. Sometimes we may not know about fully a matter to be able to have that sort of input and be an effective check and balance.
I'd just make an observation in relation to that as well. If you're a regulatory body and you have the power, and I don't want to get into local politics here, but if you're a regulatory body and you have the power to prosecute, the issue is one of loss of objectivity. And you have a reputation that you wish to maintain, as well as looking at matters subjectively. if a brief has to go to the prosecutor stands, he looks at all of the facts, he looks at the law, he stands back and looks at it from an objective point of view and says, right, there are a number of considerations here which I have to take into account, and I look at it objectively, not subjectively, and I will make a decision as to whether this matter should go forward. And it's that objectivity, the sense of fairness and justice, which is brought to a matter which is very, very important for the rule of law to be maintained. You can't then have a system of victimisation by a regulatory body, which may have taken a dislike to a particular individual. You've got someone who is entirely independent, looking at the matter and saying, no, this shouldn't proceed.
Can I just follow up on that, because there was, I won't mention the agency, but there was a situation where the agency said that they didn't want to prosecute because it would impact on their reputation. And my immediate reaction to that is, well, you shouldn't allow your concern about your reputation to cloud your judgment as to whether or not there should be a prosecution. And in that instance, I was insisting that the case be prosecuted. And the agency was resisting that on the basis that it would have an adverse impact on their reputation. So this is an example that Rowan just picked up, that where that actually has happened.
Good morning. I address this question to all three on the panel, and I preface it with an observation. My observation is that the rule of law is an extremely fragile flower, and it is very easily undermined, and once it's damaged, it's extremely difficult to rebuild. My observation about the matter that Kevin just alluded to is that, in fact, an agency that is robust enough to endure a prosecution that may, on the face of it, give some momentary reputational damage, in fact, enhances the reputation of that organization, because it shows that they're willing to pluck out the bad eggs. And this brings me to my question, which, as I say, I address to all three on the panel, and that is picking up on the suggestion of an international police force and an international court to adjudicate offences brought presumably through an international prosecution service, having been investigated by the international police force. Quis custodit custodes? Who oversees the police? Who oversees the international prosecution service? And what avenues for appeal from the international court? I like very much the ideas that were put forward in the panel. I wonder how far they've been developed. My apologies if this is a too searching question.
Well, it's a searching question. If you're seeking the truth, the reality is it's been talked about as to whether it's going to be achieved. I'm not so confident, unless we can break down the barriers, and it's the jurisdictional and sovereignty barriers that are really the biggest obstacle. We're there in part, and there's sort of layers of it, and there's pockets of it in various parts of the world. And I think we're seeing it increasingly. What's going to happen? We're going to see it develop regionally, like the concept of a Eurojust, an America's Just, then an Asia Just, and an Asia Pacific Just, or something like that, where we come together and we can move within our jurisdictions a lot more freely, a lot more effectively and properly. Whether we then develop regional courts, I don't think it'll ever get to that stage. I think it'll be mainly at the law enforcement level. But I mean, all the points that you make eventually, because I can see a layer, a global layer that will occur. Just like in the federal system that we have in Australia, or also the Confederation in the United States as well. They have a federal layer above the states in Australia and in America. And I would see that we're going to have an international layer over all the states and jurisdictions of the world. And then within that layer, of course, we will then be developing the appropriate internal checks and mechanisms to deal with proper conduct and behaviour, maintaining standards, as we would domestically. It's just going to magnify and expand at an international level. And we would then probably develop, you're right, we'd develop an appeal process above the trial process. We need to. And that has to be worked out. But I can't see why we can't have that layer that will wrap all our legal systems, and we can then operate truly internationally.
I see one of the major obstacles is in relation to an international police force. International court dealing with it, I can't see much problem there. But from where do you draw the international police? How do they work within a jurisdiction to effect arrests and exercise search warrants? From a practical point of view, that's going to be very, very difficult. And there needs to be a great deal of additional development in that area, particularly in this region. I think there's just, currently the capacity is not there. The rivalries are there, and this all has to be overcome. I hesitate to say it, but in relation to the ECCC, the court that I'm sitting on at the moment, there are interesting relationships between our prosecutors, our investigating judges, and judicial police, and actually getting the judicial police or the police force motivated to effect arrests, to assist in inquiries, is difficult. So we are coming from an international level and going into the domestic level, and that's very, very difficult.
Question is posed to all three of us, so I'll give my 2 cents worth. I'm fairly pessimistic about an international tribunal or even an international police force. And I mean, if there was to be an international tribunal, it would have a very narrow remit. I think one just has to go back to understanding why we have international criminal tribunals now and how they've developed. They've been primarily for the worst crimes possible, war crimes, crimes against humanity, genocide. And why is it that you need a tribunal on an international scale? And it's because oftentimes these crimes are perpetrated by those who are in power, and the state has fallen apart, and so that you cannot prosecute those who are responsible. I'm not so sure if that's really true about financial crimes generally, but it may well be that you will have cases where perhaps it's a head of state who's charged with kleptocracy, where you're stealing from the state. Maybe a tribunal might be appropriate in that case, following from how we have international tribunals for war crimes. But I would think that we should concentrate more on strengthening mutual legal assistance. I don't think we should really give up. And I think these ideas that some of these things that we've talked about today on the panel, I think really should be furthered, these more innovative approaches on how you can strengthen mutual legal assistance. I think Judge Downing hits it, bang on the nail, talking about the need for unity of interests, the need for bottom-up rather than imposition, the need for states to agree. I think that's really what it takes. Those are the ingredients for having successful cooperation. And it's how you build those 3 elements going forwards. But as much as you do that, I think you have to remember that in this area of states cooperating with states, politics is something that you cannot escape. And I think the Edward Snowden case reminds us of that. I mean, I don't think it's helpful to talk about what happened with Edward Snowden here in terms of the rule of law or law. It's simply politics, and it's part of the nature of these international agreements that there would be a certain degree of politics that will affect decision making. And so there will be some cases where you just can't escape that.
Thank you. I'm Agnieszka Millard. I am a judge at the ECCC. I came from Europe, and this latest topic woke me up. It is to international court and international cooperation in general. I thank you, Professor, for this last remark. I also had my reservations about this daring idea, but I think as long as we dream, there is a chance of future implementation. For the time being, I would pause. The obstacles against actual enforcement arising from the want of treaty basis and the constitutional obstacles. And our recent experience in Europe proves it, that even if we have the political will and we have the political framework in the Framework Treaty of European Union, still our national constitutions at times put ban against by all means wanted, in practical terms, possibilities of intrusions into our jurisdictions by other states' police forces. I'm talking about the questions of European arrest warrant and hot pursuit that caused constitutional issues in both Germany and Poland. And we had a big problem because we don't want our constitutions to be easily undermined. We still want our constitutions to protect the values that protect citizens against, I would say, lightly giving them out. So there was a need to go through the constitutional process of amending so that to adopt these instruments. I am also reminiscent of the cases in Kosovo where I worked as an international judge, where on the wave of this fashion for international cooperation, which was sort of done in a very impromptu manner due to the lack of legal instruments in the emerging entity, which was Kosovo at the time. Kosovo interim administration started extraditing Kosovars, own citizens, against a clear prohibition on the constitutional level. And the question was asked before the court whether this was possible, whether we could say that the Security Council resolution establishing interim administration, UN interim administration, may go as far as to allow trumping constitutional ban on extradition in the name of what? In the name of feasibility. So we would need to first of all interpret the mandate that goes as far as to allow extradition. Second, perhaps if we say yes, engaged in a balancing exercise whether it should be extradition anytime someone asks for extradition, or whether should be a consideration given first whether the prosecution locally was possible, and then would come into play the agreements on legal assistance, bringing witnesses in, sharing information. With this sort of handful of thoughts in mind, I would say international police, yes, but Interpol type, to the effect that it shares information. But when it comes to actual enforcement and, moreover, legal validity of actions before the court, so that the results could be used as evidence in court, I think this is a very complicated issue that would need to be designed in detail and fully agreed, not only as a political consensus, but on this very technical level, and I would echo Andrew Cayley that the devil is in detail when we are talking about the law. But since I grabbed this microphone, I cannot resist a temptation, because we are talking about the international standards and financial crimes. When I put the two together, the question that pops out is, what, gentlemen, do you think really about the illicit enrichment? How does it work in Hong Kong or your other respective jurisdictions? We had always, in all my international exposure, big problems with illicit enrichment.
It's the noonday gun, that's all right. It's 12 o'clock.
Thank you very much.
It wasn't because of what you said. Although we were hoping you'd stand in front of the gun. I think they've got it in the wrong direction. Well, can I just comment firstly? We've had mutual legal assistance around for a long time now, and it's not working. It's not working as well as it should. In fact, my view is that many occasions it's just not working at all. And it reaches a point with us that are involved in the prosecution of transnational financial crime, that we then try and confine the case that we're going to prosecute to what we can prove within the jurisdiction. And I know what has been said by both Rowan and Simon about trying to improve the current arrangements and structures. We've done it, and we've pushed it. We've tried to see what we can do about improving it, but we've still got the same problem. And I think it'll always be there because of the very issues of different jurisdictions doing different things, having a different mindset, different approach. And I can never see us getting around that. I can never see us getting around that. And also the ability of being able to frustrate and delay within that particular jurisdiction any request that's made. So the only solution I can think of is, as I said, having an international police force and an international court as well that deals with the transnational criminal and transnational crime. Very specific. Otherwise, they're getting away with it. They are really getting away with it. And the major operators, the major miscreants, are not being brought to the courts occasionally, but not as often as they should be, simply because there's a little bit done here, there's a little bit done there, there's a little bit done over there. And in the specific jurisdiction, in isolation, it's not that bad. Or you may not be able to prove a criminal offence. And unless you can show the big picture and deal with it as a big picture, then it's going to be very hard to get the major players in transnational financial crime. On the point about unjust enrichment, we do have a particular section under our Prevention of Bribery Ordinance where officials who are living a lifestyle exceeding their official emoluments can be prosecuted. Now, we haven't prosecuted one of those cases for a long time, and simply because there was a spate of them we did pursue under that particular provision. Then it became very complicated because you had to get a forensic accountant in. Then you could come up with all sorts of excuses and claims in relation to loans and deals, and it was very hard to prove the case. I mean, it's always difficult with financial crime because you seem to have an obstacle with the judiciary. Judges and juries having the ability to be able to understand and deal with these cases and to explain them. If you're a judge alone, you've got to write it up, you've got to set out your reasons. It becomes very hard. When you're a jury, after a protracted trial, complicated transactions, you're lost. So what happens? You're in a state of doubt. So you're obliged to return a verdict that you're satisfied beyond reasonable doubt. So the tactic will be to delay the case, create as much confusion, and you've got a doubt. So these are problems, but the issue of unjust enrichment, we should be targeting and addressing more readily. We have a very extensive array of official corruption offences or corruption offences, also private sector. And we're also using, and I can say that actually Hong Kong was the initiator of this, is the offence of misconduct in public office, common law offence. It's now taken off in the United Kingdom. So we use that where you don't have to necessarily show any bribery, just that somebody has misconducted themselves in relation to or in the course of their public office.
On that point, I think in Australia, the Australian Taxation Office has the ability to call upon someone to justify their assets on the basis of a betterment statement. So if you, and there's a reverse onus which is placed. So, yeah, so if you can't justify it, you will then be the subject of prosecution ultimately. I think the most transparent system in relation to that is in Norway, where your income and your tax is actually available online. And if you think your next door neighbour has just bought his Mercedes-Benz 500 with all the trimmings, and he's done this on his income equivalent of $50,000 a year, you can look up to see what his declared income is and notify the taxation department, who will then call upon him to justify it. So it's an entirely transparent process, and it causes a great deal of trouble, I understand, for the taxation office, because neighbour is constantly dobbing in neighbour concerning this. But it is a real issue, and the issues of proof are interesting. Consideration that was raised by the DPP as to whether you put these things before a judge alone or before a jury raises another issue in relation to compliance of common law-based countries with the provisions of the International Covenant on Civil and Political Rights. Because if you put a matter before a jury, how are you going to comply with the requirement that someone should understand and have the reasons why they are convicted? Because a jury does not give reasons. A jury gives answers to a series of questions put to it by a judge. The ultimate is, do you find this person guilty or not guilty? But you have no reasons. Whereas if a complicated matter goes before a judge, at least you'll have reasons as to why the person has been convicted, and there will be compliance with the convention.
I want to add a couple more points on the illicit enrichment. Judge Downing's talked about possible human rights issues with illicit enrichment, reversing the burden of proof. But I think what Kevin has also mentioned is that hasn't been used in Hong Kong simply because it's been difficult to prove. I mean, it's based on the idea that you can't explain where your wealth has come from. Well, in a place like Hong Kong, where the markets, property, stock market, there are many other sources of possible wealth, even for civil servants. The offense doesn't become effective anymore. And that's why I think that the prosecutor's darling now is, of course, misconduct in public office. We're looking at what the person's actually doing in office, and does that violate certain standards. And I'll have to say, yes, we have been a leader in this area, but I think lately it's been giving us some problems, not only just in the clear definition of the offense by our courts, but of course these matters that we've seen involving very senior officials, they all seem to trace back to this offense of misconduct in public office. And I think it's a defense that's hard to apply in practice. But just back to illicit enrichment, the Australians have been doing something very creative. Rather than making illicit enrichment a criminal offense, they're using it as a basis to confiscate property. And I find that very interesting, because it's a way to reverse the burden, but only in respect of not someone's liberty, but property, saying that property is tainted. Go and tell us, justify. You can't justify on the basis of your salary. Justify through other means. If you can't, then the state takes it. And I'm very interested to see how these laws, I think they've only been enacted in the last few years, see how they will do. I think we've got 5 more minutes for any more questions or comments. Imagine you're all pretty hungry as well, too. Any final point or question? Oh, yes. Andrew.
You mentioned that there's going to be a new policy document coming out this week. Are you in a position to tell us more about that?
You're going to leak this to the media, are you? We have a prosecution policy practice document, and that was issued and published in 2009. Part of my tenure of office, I've been rewriting it, so that it has a strong commitment to human rights and addresses a number of current issues and trends. I will be announcing that this week, probably on Thursday, but it'll include issues that are very topical at the moment, like public order events, human exploitation cases, the role and function of prosecutors in relation to those areas and the policy guidelines, and also our treatment of human rights, fundamental rights and freedoms. There's a statement or extensive statements made in that regard. And I've also tried to simplify it. You'll probably recall the current document, fairly wordy, and I felt that we needed to be very crisp and accurate with our language, and that it was also in understandable plain English. And so I even had an outside consultant look at it, who's an expert in plain English documents. So we've had input from various sources, and I hope that the new document, which will be called the Prosecution Code, will be one that is up to date and comprehensive, and one that will be understood by all. And that's the purpose of it. I strongly believe in publishing the guidelines and the way you conduct and handle prosecutions. So it's not only a means by which we fashion our conduct in that handling of prosecution cases, but it's a measure for others to make sure that we're doing the right thing.
Any other final? Okay, then that just leaves me to thank the speakers. Judge Downing, I know you've traveled a long way, so thank you very much for coming here and sharing your experiences and thoughts with us. EPP, I know you're in court this afternoon, and I think if we were to ask you what you're doing for the rest of this week, you're going to tell us that you're pretty much in court every day, and I think that's quite admirable. So thank you. We're very fortunate that you've had time to give to this event. And thank you all for your attention and your questions. Let's join me in thanking the speaker.